I think I'll start. So welcome everyone to this special panel on trade dress. I'm Beth Webster from Swinburne University. It's my pleasure to introduce you to the three international experts we have on the topic. So today's the first time, I think, in EPIP that we've had a special session on trade dress. And it's actually quite a complicated issue, as I found when talking to people. It's confusing from a legal point of view. In some jurisdictions it seems to be related to trademarks, other times to design rights, sometimes to informal IP like passing off. It's confusing about what its economic role is, how does it function economically, and how should it function economically, I think are quite unclear. So to clear the air and to have a final word maybe on the topic, I've got these three speakers, and what I'll do is I'll introduce them first. Then they'll go through and they'll speak, and then we'll just go through to questions. So the first speaker is Estelle Declercq. She holds degrees from the Universities of Liège, George Washington and London. She's currently Professor of Intellectual Property Law at Nottingham, but she also practiced at an international law firm in Brussels. Estelle's been a member of the Copyright Expert Panel of the Strategic Advisory Board of Intellectual Property in the UK, and is now an expert advisor at the UK Intellectual Property Office. The second speaker is Alan Marco, who's the Chief Economist at the US Patent and Trademark Office. His research focuses primarily on patent policy, with particular emphasis on uncertainty in IP rights. He's studied court errors, the consequences of uncertainty on firm strategy, incentives for consolidation and regulatory delay. Alan received his PhD in economics from the University of California at Berkeley and has previously held positions at the Williams School of Commerce at Washington, Lee University and Vassar College. And then the third speaker, another legal person, is Dan Hunter, who's the founding dean at the Swinburne Law School. He's an international expert in internet law, IP and the cognitive sciences models of law. He holds degrees from the Universities of Cambridge, Monash and Melbourne. Previously, he's taught at law schools at QUT, New York, the Wharton School in Pennsylvania, Cambridge and Deakin University and Melbourne University. And he's still young after, I don't know how many universities he's been at, Dan, but
yeah. They always send me out.
His most recent books have been the Oxford Introductions to US Law, Intellectual Property, Amateur Media, and for something completely different, he's written a book called For the Win, How Game Thinking Can Revolutionise Your Business. And that last book's been translated into 5 other languages. So please, can we welcome the three speakers, and we'll start off with Estelle.
Thank you very much, Beth, for organising this session and for the introduction. So I thought that I was going to do, in 15 minutes, it's a bit of a challenge, but highlight the main aspects of EU law in relation to trade dress. And I'm only going to speak about 3-dimensional aspects, not two-dimensional aspects, and then give you a few thoughts about whether the state of the law is satisfactory or not. And so the first thing that happens with protection of trade dress by trademarks, and by definition there's also designs and copyright and patents involved, but basically about trademarks, is that there's a limited supply of shapes. And packaging has to do with shapes, obviously. But also because some shapes are more attractive than others, and so many traders want to use those shapes. And therefore there's a lot of competition concerns. Should trademark really be concerned with protection of shapes? And that has not always been the case, because with TRIPS now it is something that member states can use, but it's not always been the case that shapes were protected by trademark law. They may have been protected by passing off or unfair competition, and not by trademark law in many countries. But now in the EU it is a standard thing because it's inside the EU law. So the first question to ask is whether the EU trademark law, which has subject matter exclusions which enable this competition between traders, does the law really work? Because it's been interpreted by the Court of Justice. And to some extent is satisfactory, to some extent still very unclear or uncertain. And then there's the problem of having an overlap between not only trademarks and designs, but that's what I'm going to focus on, but trademarks, designs, copyright, and sometimes patent as well, between all these different IP rights. Does really trademark law, and this is what I'm going to focus on at the end of the speech, just really trademark law make design law redundant when you're talking about shapes? And redundant or, overprotective. But I'm going to talk about whether, a trademark law can really make design completely redundant. I'm not going to talk about the overlap between trademark and design when they both apply to the shape of the packaging in question. So the title, I've looked a bit about the title that was assigned to us, and I thought, well, what's a design-intensive industry? And so I did the Google search, like we do now, and bumped into this OHIM EPO study from 2013, which had the definition of an IPR-intensive industry, and it's basically an industry that uses a high number of intellectual property rights per employee. So it's basically down the chain. It's those competitors who want to use the shapes or the packaging. And supposedly, according to this study, more than half of European industries are considered IPR intensive, and it spans all different types of goods. So you have high-tech industries, manufacture of sports goods, games, toys, computer games. And actually, when you look at the case law, it is actually true, because the case law involves lots of different sectors. The case law, at least that went up to the Court of Justice, and it's the only case law I'm going to talk about. And so there's a big potential, there's a big potential impact on competition because of the trademark protection of shapes. It's not merely an academic issue. And when you look at the numbers, at least from the community trademarks, which are registered, when applied for and then registered, between 2012 and 2014, there were 300 plus. It fluctuates a little bit, but when it grows, around 350 CTMs that were registered. It's only 0.5% of the trademarks which are registered at EU level, but it's still 350 trademarks. And so if there are trademarks which are really attractive shapes or shapes which are really important for competition concerns, then 350 is quite a lot when you think about it. And that does not take into account national trademarks, because in the EU you can have obviously also trademarks which are not applied for at EU level, like a CTM, but a national trademark as well. Now, I'm not going to bore you with all the details, and I'm going to go really fast, because all of you, I'm sure, know about these things, but it's just a nice little reminder so that I can draw conclusions from it, is the rules for shapes in the EU are the same for any signs, trademark, so you have to have a sign, and so a shape is a sign, we know that. You get graphical representation, and the sign has to be distinctive of the undertaking goods or services. And as well, for shapes, there are specific rules. And these rules make sure that some shapes are excluded so that there's no competition concerns. The first interesting point is this notion of sign, which was not really defined, and we have had some case law on this. The Dyson case was a Court of Justice case, and then we had a Zynga case, which is recent, which is a UK case, which now makes really clear that a sign is not just any information. No, because information, a concept couldn't be information. A concept of a vacuum cleaner, a container in plastic is a concept. You can have loads and loads of different shapes. So in Dyson, they said, no, that's not a sign, because then you have basically an IP right which amounts to a patent in some ways via trademark law. So you got to register the specific shape of that specific container in plastic for that specific vacuum cleaner. You cannot just register all possible shapes. So that is fine. That competition concerns are somewhat addressed, I think, quite well in these two decisions. Zynga is about the Scrabble, little pieces of Scrabble, where you have, they wanted to register all possible combinations of letters at whichever corner of the Scrabble piece in the case, and they said, no, you can't do that. You have to make the sign really specific, because otherwise you prevent competition for other games that may have combinations of letters and numbers in different positions. So that's notion of sign. And then, obviously, when you want to register a trademark, there are, as I said, the special rules that applies to shapes, and one of them is Article 3.1e, and that's the most important one because it only applies to shapes. Actually, it doesn't apply to two-dimensional trademarks, which is a mystery. Why not? Because they could be two-dimensional trademarks which are natural or functional or ornamental, and that all traders should use, but I'm not going to talk about that. And basically, the public interest underlying this is, as you imagine, is that we don't want in Europe to allow registration of a mark in order to acquire or perpetuate exclusive rights relating to technical solutions, and also shapes which you couldn't get a patent on or you couldn't get a design on, but you try to get a trademark on. So it's not only shapes that you would have had or you could have had a patent or a design, but also those shapes you can't have a patent or design. Oh, I'm going to get a trademark instead. So that basically, I can't get an IP right and get another one by the back door, sort of. So it basically deals with this, what I call in my book on IP overlaps, the negative overlap and the subsequent or a posteriori overlap. So you had a patent, well, I'm a Lego, I have money, I'll throw a bit of money to get a trademark on my Lego bricks to just prolong the life of my Lego brick design. And so big cases in Europe involve Lego bricks, and one of the first cases which interpreted 3.1e, these three different shapes, so the exclusions, the signs we consider exclusively of the shape, which results on the nature of the goods themselves, the shape of the goods which is necessary to obtain a technical result, so that's the case which involved the Philly shave from Philips, and then the shapes which give substantial value to the goods, and that's the one which I want to take as an example of, and this, I don't know if you can see very well because the contrast is not so good. That's a trip-trap chair and from Stocker, and this is the Bang & Olufsen speaker, which were the two cases in which the Court of Justice has interpreted 3.1e3, which deals with the concept of substantial value. And in fact, what is, a shape that gives substantial value to a good? I mean, I ask you, out of the blue, you don't know about EU law, you'd think, that's a good question. Why do I buy this, speaker? Do I buy it for its appearance? Or do I buy it because it's a trademark and I think Bang & Olufsen right away? I mean, if you've never seen it, you probably never thought that was Bang & Olufsen. You don't think about the shape as a trademark. You think about, that's quite nice in my living room because it's so slim and slender and whatever. And the same with the trip-trap chair. I was like, that's very practical. I can use it for the life of my child until it grows and I don't have to buy so many shares. So that's the concept of substantial value. And actually now we have case law which interprets this concept, and it's the Court of Justice have used this concept of substantial value in a very broad way, and to exclude not only, to address not only the overlap between, you'd think, copyright and design and trademarks, also patent and design, and trademarks, because you could very well have had a patent on this, not just a design. There's so many different aspects of that chair that you could try and get an IP right on. And so it's not only those attractive shapes for their appearance, think the Bang & Olufsen speaker, but also those shapes which makes product more comfortable or safer. And actually in the new case which deals with Kit Kat, I forgot to put the Kit Kat little, but if you're from the UK, you know what a Kit Kat looks like, so you can explain to your colleagues afterwards. The way that it is made and the way that it's so functional, when you break the Kit Kat to eat it, so it's a chocolate bar, it's so easy, right? And so this is a shape that probably most traders would want to have, and you wouldn't want to have a trademark on. But this is still pending in the Court of Justice, and the Advocate General has said, well, those shapes, they're a bit like types, patentable shapes that you wouldn't have gotten a patent on, but they're very practical. So they are shapes that give more strength to the article, or use least materials, or facilitate convenient storage, or facilitation. Or here, it's facilitating your way of eating the Kit Kat, because it's the best way to eat that type of chocolate bar. So this is only the exclusions. And my point here was to say that, yes, the Court of Justice has got a purposive interpretation, it's quite broad, it excludes quite a lot of trademarks, but there's plenty of grey areas still, because, when you look at this, I mean, you could get lots of interpretations, because the wording is basic. It's legislation. It's not got a long list of criteria, what you have to look for, what is substantial value, etc. So we're getting there, but there's a sort of a grey area where there's going to be lots of trademarks which are borderline and could cause competition concerns, because we don't have an interpretation of those trade exclusions, clear one yet. Now, this distinctive character is something that all trademarks have to have, but for shapes, it's more difficult to have, because when you think of the Bang & Olufsen shape, you'd think, well, if you didn't know it was Bang & Olufsen, you'd think, well, I look at that and it's nice, but I don't think of it as a shape, as a trademark. And also because, generally, when you buy a product or even packaging, it's going to have the name of the, the word mark or figurative mark on it. So if you have a bottle, it's not just the bottle itself, it will have the name of the manufacturer and the trademark, word trademark as well. So consumers don't really think of packaging as an indication of origin. And so the Court of Justice has said, well, it's the same, it's distinctive character, but you have to also prove, if it's a shape, that the shape departs significantly from the norm, customs, and of the sector. And in fact, in some cases, they even said that they have to have individual character, which, if you know about design law in Europe, that's the criterion for proving that you can get a design. It has to be new and have individual character. So it's like, well, that's shocking. So it's the same requirement, sort of, or the same word that they use for both trademark and designs. Hence my link with whether trademark law makes design law redundant in some ways. So the funny thing as well is when you think about the law, that the way it's done, yeah, shapes must not have substantial value because then they're excluded from trademark law, but at the same time, they have to have a significant enough variation from the norm to be somewhat striking, because otherwise you can't have a trademark either. So you got to be in the middle, it's a kind of dissensilla, you're going to be in the middle, and not too attractive, but not too plain either. Otherwise you can't have a trademark. And also there's something disturbing a little bit, because you can get a trademark on a shape, on packaging, for trade dress, if the traders in the sector educate people to see that the shape is indicative of origin. So if you've got money to throw in marketing, then you can get a shape mark. But if you don't have enough money, or you haven't educated your customers, then you don't have a trademark on the shape. That's could be a bit abusive in some ways. So I'm coming to the end and to the how much time do I have? A minute. To the end of it. So I gave you these examples that have actually been litigated on. There are many examples where you have had some shapes, here bottle shapes, the Rubik's Cube, the Jeep grill, etc., the Lego figurines, which have been protected as shapes. So, as I say, it's not an academic issue. And at the end of the day, trademark, when you look at it and you compare it to design protection, and I'm going to go quite quickly on this, is much better in many situations. First, sign, appearance of the product for shapes, more or less the same to prove in design law and trademark law in EU. Distinctive character, much easier to prove than novelty and individual character, although if you have a shape, you might actually it might be the same thing, because individual character in design law and in trademark law, that's what they seem to use for shapes. Excluded subject matter, there's some overlap between trademarks and designs in terms of the excluded shapes, but there's no must fit or must match in trademark law, so you get more shapes that could be protected by a trademark law than design. So you think, why should I use design right? I should just get a trademark. And then the best bit is the level of infringement. In the UK, we've seen that a lot in litigation. You get a design right, it's valid, but bingo, it's not infringed, because the test is the informed user. An informed user is a person who really looks at the stuff in detail, where the average consumer in trademark law, as the UK courts call it, is the moron in a hurry, unless you're buying really luxury goods, right? So it's much easier to prove there is an infringement of your trademark, especially if it's identical goods, identical sign, than if it's a design. And all the more so if your mark is repute, because then you have more, you have more power, people know about your mark more. Although there's due cause under 5.2 if you, in the trademark directive. So there's a bigger exception than under 5.1. So, last but not least, and you all know this, trademark lasts forever, bingo. So why should I get a design, right? And therefore, that's what I'm worried about, and I'm worried about, I'm concerned. You try to think about the two laws and think, why, when you think about it, why do we really have design rights? We should just use trademarks. And it's a problematic, because if you decide to have shapes which are protected under trademark law, there's always going to be an area of overlap or of uncertainty, even if you have excluded subject matter. And we've seen it in the case law, and we're going to have to have so much more case law to find out which shapes are excluded and which are not under Trade 1E. First, it reduces competition, and with time, it clogs the amount of shapes that are available, because obviously they're going to not be available if they're used all the time for centuries or millennia, until the end of the Earth, which might be close, and then favors rent-seeking, because you think, well, I'm not going to have a design, I'm going to have a trademark instead. And the funny thing is that it favors, in effect, mundane design, because you don't want to make it too aesthetic, because then it's the realm of copyright and design right, which expires, and you don't want to make it too plain, so you got to go somewhere in between. So if you think, strategically speaking, if you're a company, you know, well, why should I invest so much in aesthetic design? Because I'm going to lose my IP rights. So just go in the middle way, and it's a bit striking, but not too much. Depends what your strategy is. And the impact of these three consequences exists in all the different sectors. So here I've listed some of them. So conclusion, this is my last slide. What should we do? And this is, again, more questions than answers. I saw in the panels this morning lots of people have questions and no answers. I have no answer either. I'm just throwing this for discussion. Should we go back to square one and say, should we remove trademark protection for shapes? Because we're never going to find a solution, well, this gray area will always remain gray, and shapes are more protected by designs and copyright rather than trademarks. And so have an election theory, say, well, shapes, that's design and copyright, and then, trademarks, nothing to do with shapes. Or shall we say, well, trademarks and design law have different rationales, and therefore there should be an overlap, and there should not be any problem, and too bad if there is a gray area. And my PhD student is actually looking to this issue of the rationals, if there is not actually an overlap between the rationals, between trademark and design law. And then my question is, were we really worse off? And that's really a question that I throw to the economists in the room and to the historians, if there are any there. Were we really worse off before in the countries where we didn't have protection of shapes by trademark law than we are now? That's how I will end. Thank you very much.
Thank you, Lisa.
Thank you, Beth, for inviting me to join the session here. I want to give a disclaimer up at the beginning. Number one, I'm an economist. I'm not a lawyer, so I'll be coming at it from that perspective. Number two, these comments are my own opinions and not those of the Patent and Trademark Office. Third, I'm rather unknowledgeable about trademarks, trade dress, and this entire topic area. So what I'm going to try to do here is leverage my ignorance and take a step back and think, if we're really just sort of looking at trade dress anew and design rights anew, how would we want to think about these from a policy perspective? And I have the opportunity to do that since I don't know much about them. I really can look at them afresh. So really, this is probably too aggressive a title, an economic analysis of designs and trade dress, since I'm not really an expert there. Perhaps designs and trade dress, some economic considerations. Or if I was speaking to a business school audience, we would just call it trade dress for success. Trademarks. Okay, I'm going to be taking a U.S. Perspective on this, mainly because I spent some time hanging out with a U.S. Trademark attorney and borrowed some of her slides. So trademarks, as we know, it's a word, phrase, symbol, or design. It can be a smell in the U.S. At least, that identifies this business's goods or services to its customers. It allows the customers to distinguish those goods and services from those of their competitors. Why do we think? Why do we offer this? Right, from a policy matter, why do we want trademarks at all? Well, for a couple of reasons. One, from the consumer side, right? It enables consumers to distinguish one product from another. And we think from the firm standpoint, we want to incentivize investing in reputation and high quality products. So this really only matters, though, when you don't have a homogeneous good. When you have a homogeneous good, in a sense, we wouldn't want any trademark at all. We would want competitive prices, and since there's not a quality element here, we just want those competition to bring those prices down to marginal cost. It'll be more difficult to do that in a differentiated products standpoint, right? So when we have differentiated products, when we allow firms to in some sense, in the case of homogeneous products, artificially distinguish themselves from one another. It softens the price competition, right? Raises prices, and in the case where there is a quality component, that might be something that we want in a dynamic context, right? So for dynamic efficiency, we may actually be willing to accept higher prices in this differentiated products market in order to get some more investment in quality. So just as kind of a broad brush, that's how I think about trademarks. Now, trade dress and designs, right? It's actually a very similar concept, right? But it's very particular, right? So rather than using the words or just the mark, right? We've got product's design itself, product packaging. It could be the color, the Tiffany's blue, right? It could be other non-functional elements here. So we could have trade dress could be trade dress for a service, which, as it turns out, costumes are trade dress for services, which would be this one over here. That's a service. It could be part of the product itself, right? So here we have the famed Walter PPK. It could be part of the packaging, part of the packaging in which you sell the product. So it could be on the product, it could be on the packaging, it could be on a service. All right. So here we have, right, these two different ways of thinking about it. We've got the goods, we've got the services. Under goods, we've got both the product, a part, again, like the Walter PPK. We've got product packaging, the shape of the Diet Coke bottle, for instance. Okay, so one of the main issues in trademarks is distinctiveness. And so I'm going to spend a little bit of time on this in terms of how we want to think about design rights, and in particular, acquired distinctiveness. So this is sort of the standard trademark distinctiveness scale. So you've got these generic terms over here which are not registerable. You can't have, Apple brand apples. But of course, you can certainly have Apple brand computers. That's in this sort of arbitrary context over here. And of course, you can have fanciful, sort of made up words, Kimmich for apple puree. This is why everything coming out of Silicon Valley now is misspelled, right? Because it's, Google itself is misspelled. So it's in terms of relative to the number Google, which is spelled differently. So everything coming out of Silicon Valley is misspelled so that it gets a little bit towards the fanciful term and makes it a little easier to trademark and maybe a little easier to distinguish yourselves from your competitors. Okay, but you can acquire distinctiveness down here. So some of these terms are inherently distinctive in terms of the way that the courts see it. And in some, it's not distinctive to begin with, but you can acquire that distinctiveness, right? So in terms of trade dress, one of the things that the courts have found is that color cannot be inherently distinctive, right? So you have to acquire distinctiveness in that. Tiffany can't come out with a blue and you say it's distinctive. Anybody else could have come up with that blue and used it. They didn't for jewelry, for the packaging, for the storefronts. So over time, that acquired some distinctiveness, and then the color, right, enables you to identify Tiffany. The same with the red-soled shoes of whoever that is. They'll never be in my house because I can't afford them. So, okay. So there's this issue of acquired distinctiveness, and in trade dress, this is going to be something that's really important. And I think from a policy standpoint, we really that's where the rubber hits the road. And that's where we want to really think about where design rights fit in. And so I'll get to that a little bit. So this inherent distinctiveness, right? So you could have a wavy shaped bottle. If it's a common or basic shape, it's not going to be particularly distinctive. If it's new but functional, right? Oh, it makes this bottle easier to grip. No, then that's not inherently distinctive. It may be inherently distinctive, but it's because it's functional. It's not. We're not able to trademark it because we think, well, if that's a useful function of it, then every firm is going to want to create their bottle that way. And so it really shouldn't be distinctive. We don't want that to distinguish one firm from another, that functional aspect. We want to allow competition on that. Okay, so sometimes in court cases, they bring up evidence about whether they won some design award for this particular packaging or product, in which case that's some evidence that it may be distinctive. So in terms of acquired distinctiveness, typically the mark needs to be used for a long enough time that the public immediately associates this mark with the source. And that burden of proof in the states is on the applicant. So you actually have to bring in, survey results. You have to bring in maybe expert testimony, evidence about whether you won awards, et cetera. So the interesting thing here is that you have to use it for a long enough period of time. So what's long enough? Well, that's the area of for the lawyers and the courts to decide. So I don't have to think about that too much, except that it has to be for some period of time. And the question is, if you come out with a really good design that does set you apart from your competitors, and there's no protection immediately until you've acquired the distinctiveness, then your competitors can rush in, and if they rush in, how can you possibly acquire distinctiveness? Right? You don't have a period of time over which to do that. Maybe, and I'll hold some comments on that. Right, so in this case, the Walter PPK, you've got this mark used for over 75 years. It's touted in these advertisements. There's a clear link with James Bond. There's advertising expenditures they use. They have consumer surveys that they brought. And in the end, expert declarations. At the end, the courts found this, yes, indeed, this was distinctive. Oh, except for the trigger. Trigger's not part of the product design. So it's disclaimed, you can tell because it's a dotted line. So they're claiming everything else, not the site and not the trigger, but the overall profile, is what they're claiming here. And indeed, I look at this and I say, hey, that looks like James Bond's gun. Okay, so from some economic considerations. So again, why do we have trademarks? We want to invest in this reputation. We want it for goods in particular where there's a quality component, right? Because we want investing in the quality of that good, and we're willing to take some softened price competition in order to allow for that. So why do we have trade dress when we already have trademarks, right? You could say, well, look, it's a Walter PPK. They can say it's Walter PPK and put the name on it. Consumers can still look at it and say, oh, Walter PPK, that's James Bond's gun. But maybe if the design itself is not protected, right, then they can't get the same sort of consumer utility about showing it off to their friends and say, look, I have James Bond's gun. And they say, well, it doesn't look like it. It looks like every other gun. And you say, no, look on the bottom. It says Walter PPK. They don't get, it's not the same sort of satisfaction. So, so maybe there's this consumer utility to these designs that is not purely technically utility in the sense that we use for patents, right? It's not useful, novel, non-obvious. It's still useful, though, from an economics standpoint in terms of utility. But again, think about this plain packaging. So if we have plain packaging laws, and there's a lot of plain packaging cases around the globe right now, especially in one particular country down south, where you have to think, does the mark itself give the consumer enough to sort of identify this good? If the cigarette is wrapped in brown paper and you see a little Marlboro written on it, is that enough of an identifier? So maybe we want to allow this trade dress where we really think it helps consumers to easily distinguish between these products, perhaps. And then why designs? Right, so why designs separately from trade dress? And this is something that we were discussing earlier. So with designs, right, it's a limited design right. Typically in the States, there's a little bit more latitude for some functionality to creep in. Technically, they're supposed to not be functional, not have utility, but the line on that is a little bit less than it is for trade dress. Perhaps, though, we might want designs in order to be a precursor for trade dress. And I'll mention just a little bit about that in a second. Overall, though, if we think design protection, typically you'd think, well, we want to give design protection because we want to incentivize design, or incentivize good design, anyway. I think that's on my, no, I'll stay here for a second. Okay, thank you. I should be able to do that. We want to incentivize good design. But the question is, do we not get good design if we don't have design rights? Right? Are we worried that firms don't invest enough in design? And I don't know the answer to that question, but I'm a bit skeptical. I'm a bit skeptical that we require the design protection in order to incentivize good designs. However, when we think about them as perhaps precursors for trade dress, You say, well, you're going to have limited design right, and if you can show that you can acquire distinctiveness in that time for something that's not functional, not utility, and in that period of time that you have better protection, consumers can then start associating that product design with your product, and you want to invest in that, and you want to invest in a quality product so that they can identify that. Maybe we want to allow that. It's a temporary design protection that facilitates the acquisition of that distinctiveness that you need for the trade dress, perhaps. So a couple other things here. How much protection do we want? Right. If you can think about different situations here. If we have very little, a very weak protection on trade dress, we really want to incentivize competition on quality and price of the good itself, not on and not just on the design. In other words, we want, if somebody comes out with a design and it's associated with this product, if other people can come in and copy the design, then competition relies completely on price and quality, and not you don't have some extra protection on there with respect to the design. On the other hand, we want to reduce consumer confusion, right? Maybe that people will come in and copy that design, and then it'll be associated with the pioneer, and that'll be confusing to consumers. On the other hand, where will I find my generic Zyrtec? I go into the supermarket and I look for Zyrtec, and I look next to it where I know the generic Zyrtec is going to be, and I look for the package that has the same color scheme. So maybe we want some limited ability to copy the packaging in order to actually help the consumer to find the generic substitutes. Maybe not a perfect competition. I talked about designs as precursors here, so the last thing I'm going to talk about is just leveraging of trade dress, question mark. So I want to talk about this one example, and I'll just read this quote from James Conley, who is a former member of our trademark advisory board at the Patent and Trademark Office, and a genuinely nice guy. And this is his favorite example to use, is the purple pill. So he says the patent on the Prilosec compound expired in 2001. So Prilosec is an antacid. And Prilosec heavily advertised Prilosec as being the purple pill. Generics, of course, subsequently entered. Price competition ensued. And as Conley says, but by carefully guiding the brand-loyal market segment from Prilosec to Nexium and its advertising and the use of the purple pill trademark, AstraZeneca has sustained its $6 billion revenue stream through 2005, 4 years after the original patent expiration. So what they did is they came out with a new drug, Nexium, and they leveraged that purple pill, and then consumers started associating it with Nexium. How did they do that? Well, originally they said Prilosec, Prilosec, purple pill. Prilosec, purple pill. Prilosec, purple pill, purple pill, purple pill, purple pill. Nexium, purple pill, Nexium, purple pill, Nexium, purple pill, purple pill, purple. So it's not that hard to do it, right? Pavlov figured this out. So the brand loyal market segment was guided to Nexium. But the question is, we're leveraging this trade dress, but is this actually consumer confusion, right? Are we actually leveraging the confusion and say, as the brand owner, I can confuse my own consumers so that they'll associate this purple pill with whatever I tell them to? And that's a question I'm going to leave open, and I'm going to end it right there. I'm going to say if you have questions or comments, feel free to contact me. Any complaints are best.
I'm starting the timer now. I'm going to do this in 12 minutes, so we've got some time for discussion. All right. So my particular talk today obviously is on trade dress, but it's going to focus on furniture design and the history of furniture design. So the stuff, and it's also called subtitled The Law of Design in the Age of Mechanical Reproduction, which for any Benjaminists out there, it will become clear as to why that is towards the end. Just very quickly to give you some sort of context as to why I'm focusing on furniture design and the furniture design industry. The work I do these days is mostly about material culture. and the interaction between objects that embody intellectual property and the way that the firms have used the intellectual property system and changed the intellectual property system in order to meet particular ends, and that they themselves have been changed by that. So this is basically about intellectual property objects. So various studies that actually focus on mostly trade dress related things actually include a paper on Lego, one on handbags, one on Barbie, and this one on furniture design. Okay, so the basic thesis here, and I'm going to try to do this in the 10 minutes and 15 seconds that I've got left, is to talk about how the furniture design industry from its earliest stages has used this idea of the incoherency and the difficulties of understanding trade dress and design to regime shift between different intellectual property regimes, and how they've tried to change those regimes in order to meet their particular interests, and how when particular historically contingent aspects of the intellectual property system have come along, they've changed gears and shifted often into other regimes. The end point in relation to this will be Walter Benjamin's aura of authenticity still really has an incredibly strong hold over the concept of trade dress and design, but I won't push that too hard because I just don't have time. So the three things that I'll talk about now, one is about trade dress and design overview. We've heard a lot about that, so I can do that really quickly. Then I'll talk about the history of furniture design and how that applies some interesting lessons, or gives us some interesting lessons in relation to trade dress, and then talk about the legal responses, in fact, the trade dress and design related stuff. So trade dress and design law is incoherent. Let's just posit that. It's absolutely ridiculous. It comes from completely bizarre, historically contingent industries in every different jurisdiction. It's internally inconsistent within those jurisdictions. That is to say, in pretty much every jurisdiction you can name, if you have something that involves a shape or a colour or all of the stuff that we've been talking about now, you can pick and choose. You can decide that it's going to be a patent, a design patent. It might be a registered design. It could be covered by copyright. It's probably a trademark these days. And it's really just up to you as to which is going to be in your best interest. But it's not coherent. And all of the channeling doctrines that you have within each country don't really work very well, right? You know, and interested actors will always find a way around those particular things. I'm just going to posit that. You can disagree with me in the question and answer, and I'm happy to defend it. There might be some examples of a really, really clear, principled trade dress and design regime, but I haven't come across it yet. I'd be really interested if any, Ukrainians or that can demonstrate to me that there's a really good reason. Sorry, I don't know if there's anyone in the room. I have no idea what the Ukrainian law is. Anyway, so let's just talk about furniture design, and I'm not going to be talking about any given country. This ranges across a number of different countries, so you can say yes, but, and I'll say, okay, well, you're probably right, but this is what happened in relation to it in certain areas. So furniture design is based around the idea of the copy, right? So in the earliest period, in the artisanal period, which basically is up to the era of industrialization, which is sort of mid-1800s. You basically had artisans working in atelier, and they would copy from each other. And there were copy books that were circulated, and part of becoming a maître ébéniste, a grand craftsman, was in fact the ability to copy, to create works that were really, really significant for typically royalty and nobility, right? That is in fact what you became when you weren't a furniture designer, you were a craftsman. It was always men. And you were producing for royalty and nobility. And your ability to actually craft these things in a way that was consistent with other nobles from the grand courts or whatever, then that's actually really that was your craft. And we didn't need intellectual property then, of course, right? Because when you went to Chippendale or Sheridan or Hepplewhite, you were buying it from that particular craftsman. Okay, and so you were spending a huge amount of money. If you were, William, 5th Earl of Dumfries, who spent what was in today's terms £4 million or £5 million to outfit his house, right? Or actually it was a castle, obviously. So anyway, so copying is sort of built into furniture design from the start. Then we ended up with industrialization, of course, and you don't need to be a Marxian to understand that there is a separation between the work product and the eventual value of the thing. And so that then introduced concerns about intellectual property, right? Because we're starting to produce these things on industrial scales. And so what that actually meant was there were a series of mechanisms that were introduced in order to try to capture that value within the factory, because the factory had to spend a lot of money, the factory owner had to spend a lot of money to ensure that this thing remained with them, right? And so we started to see the emergence of design law. It was mostly around certain sorts of design laws, different in each country, sometimes copyright, sometimes patent, sometimes it's its own sui generis thing, but it was mostly focused upon ornamentation. And we see that pretty much throughout design laws to this day, right? It's really about the ornamental features as applied. So, you know, things which were utilitarian and functional excluded, things that were industrially applied, ornamentally applied was the sort of the core of design law. We also saw, particularly in America, at the end of the 19th century, the emergence of a lot of patents over furniture design. So patent was used a great deal. And within Europe, you sort of saw a little bit in relation to copyright, and we saw that a little bit later on. But I'll talk about that in a second. So the big thing that caused a problem for furniture design in relation to design and trade dress and led to the sort of the mess that we have at the moment is modernism. Modernism is really stark, right? This was called the machine aesthetic at the beginning of the 20th century, and it was built in the factory. It took its reference points from the factory. It was supposed to look like it came from a factory, right? It's steel and leather and clean looks, no ornamentation, as you can see there. All right, so this is the cantilever chair. And I would actually probably be able to find a way of doing it. Who cares? Right, so the cantilever chair, I'll talk about in a second. And this is Mies van der Rohe, who also created a cantilever chair that became important for a little bit later. But this doesn't have any ornamentation. So whether your particular reference points were Bauhaus or the Steyl or the Wiener Werkstätte, all of these sort of movements meant that we ended up with form follows function, right? This idea that we're going to have very, very clean lines. And so this idea that started to emerge was, how are we going to protect the thing that's not industrially applied or ornamentally applied? We need to be able to protect shape. Okay. So you look here, this is the difference between the decorative period and the machine aesthetic of modernism. And of course, you know, if you look at the chairs that we have right here, or the chairs in your home, right, we still have a modernist, or sort of a mid-century, actually, it's early 20th century modernist kind of frame that we still think about in relation to furniture design. Okay, so designs law is not going to work really, really well for this. What's the industry going to do? Well, it's going to try to apply every single area of intellectual property, every single regime, in order to try to benefit. And so there's this fantastic series of cases that occurred in Northern Europe, especially in Germany in the 1930s, where we dealt with, was there copyright over the cantilever chair? And in fact, they said yes. The relevant court at that time, I can't remember which one it was, said yes, there's a copyright over this. It's the first creator of this was a Dutch designer called Max Stamm. And there was copyright over this, and the licensee of Stamm's work went on a tear and basically tried to stop every single version of a cantilever chair, right? This is a cantilever chair, you know, which this one's a Breuer example, but he was able to get that. At the same time, Ludwig Mies van der Rohe also claimed ownership over the chair, but this time on the basis of a patent. Because of this particular form that he has here for this, I think this is the Bruno chair, which actually was slightly different and was patentable, at least so it was claimed. So we started to see within modernism this attempt to try to protect this particular form through various different regimes. More recently, and this is where we are these days, that in fact what we see is that furniture design is seeking to use the things which Estelle and Alan has already talked about, right? Which is to say that we're going to start using trademark as trade dress, right? In this, we're going to actually seek to get registration over the shape of these particular chairs. So Cassina has got a registered trademark in the United States and many other countries. over this particular chair, which is Le Corbusier Grand Confort, and a range of other ones over the LC4. Noel has got it over all of Mies van der Rohe Barcelona chairs, you name it. All of the Eames chairs, Noel has got shape marks over those ones in most countries where they've actually a licensee. Now, the interesting thing about this, of course, is that this doesn't help them very much in relation to replicas. Right? And in many countries, not in a lot of European countries, but in many countries that follow a sort of a common law tradition, there's no strong protections for the shape. You can get a little bit of protection. So what in fact the industry has sought to do to try to stop these replicas is to come up with this claim of authenticity. Don't buy fakes, quote unquote. Don't buy things which are not authentic, right, that are not real. And you sort of think, well, where does that claim of authenticity come from? And it comes from, well, in fact, it was destroyed by this guy, Walter Benjamin, where the argument that Benjamin was addressing was the idea of the original within artwork. This was in the 30s, that came about as a response to photography and cinematography, where there is no one original, right? You can't say that there is an original photograph, right, unless you're sort of looking at the negative. Anything which is struck from that negative is an original. And so the idea of the aura around the Mona Lisa, or the aura around the David, is just gone, right, when you're talking about that. And that's also true in relation to this particular area of designs law and the area of applying trade dress to furniture design. So the claims these days by the authorised licensees is that ours is authentic. But if you look at that claim of authenticity, right, it's extremely weak because the claim is based upon licensing, right, and those licenses are often very new. Right, they're incredibly contingent, right? They're hard to apply. Oh, look at that, that's excellent, right? I've got one thing to do. They're incredibly hard to apply, and in fact, most of the designs that we think of as classics these days, whether it's the Barcelona chair, whether it's the Eames recliner, have been out of production for at least 20 or 30 years in the last 50, right? It was only in the 1990s when this particular style came back that these things went back into production. So the claims of authenticity are really fairly weak. The conclusion then is how should we think about this within the area of furniture design? I'm going to leave that open because I think there are more general questions about the way in which we should approach trade dress. Furniture design, as well as a number of these other sorts of objects, give us some kind of insight into that, but I will hold it right there. Thanks.
Thank you very much. So because we did start a bit late, we're sort of bang on ending right now, but I think we should take about, say, 5 minutes of questions. Maybe could I ask the panel one question? So you've given me examples of where you've got different types of law overlapping and trying to claim some sort of right over a particular shape. Is this desirable?
Yeah, sure.
From the point of view of
yeah.
well-being of a country.
Yeah, I understand your question. I understand why you're looking at me for that, because of IP overlaps. Well, there is an issue as to whether the rationales of the different IP rights is the same or not. And if it's the same, and in trademarks law it has grown, I mean, from the beginning you were saying, is to do with identifying goods, and so the idea of avoiding confusion. But now it's more to do, well, we invest into this mark and it's becoming really a product in itself. I mean, you're buying the product for the mark, for the trademark, not because it's a jeans, but because it's got a trademark on it, for example. So there has been, especially in the field of trademarks, a proliferation of aims that weren't there at the beginning. And so there's, in my view, some sort of with the investment function of trademarks in the EU, an overlap between the aims of the two laws, and therefore, why do we need two IP rights for one single effort, that is to invest into the shape in this case? So, in that respect, if the trademark's not only there to identify products and avoid confusion, then they shouldn't be, in terms of shapes, there shouldn't be an overlap, because then you've got too much protection. And the problem with trademarks is because it doesn't end, the protection doesn't end, and then you have a competition concern. If you have an overlap between, say, designs and copyright, well, at the end of the day, at some point, it will end. So there will be some sort of competition. And the only question is how long do we want this protection to be? And if it's too long, if copyright's too long, then we fix copyright. But it's not really a question of if you want... well, in copyright and designs, there can be a problem because the two aims can be similar. But with trademarks and designs, it's only in recent times that we've had this problem, because in the past, I mean, in many countries didn't have protection for shapes. So it's cropped up, and I think it's not desirable because of that. But if the aims are similar, the aims of the two laws are similar.
I just say that Irene Calabali and I have got a paper actually in the next session which talks a little bit about this, but about the proliferation of trademarks, and that I think it's hard to make the claim that these are distinctive in the way in which we care about in relation to trademarks. And what I've seen in studies of a number of different industries is that the regime shifting that takes place is probably suboptimal from a social perspective. But Irene will talk a little bit more about that in a different panel.
If you didn't have trademark protection for shapes, how would you stop people putting poisonous weed killers in Coke bottle-shaped bottles?
I don't think trademark really is the thing that I think that criminal law would probably fix that. Yes, I hope it would. I don't think trademark actually fixes that problem very well.
Well, I would agree in the sense that there are plenty of generic soda bottles out. Very few of them are actually covered by trade dress protection. The Coke bottle is sort of the exception, and you look and all the rest of them are shaped the same. So someone already, I guess, presumably could, as long as they put it in the correct aisle. I suspect that you wouldn't want to put it right next to the Pepsi. I'm pretty sanguine about the market being able to handle that one.
This is a question I really don't know how to answer myself, because I keep going back and forth. Sometimes I think we need protection because we do want to protect against, not so much, I don't look at the protection for the owner, but I look at the protection for society against too many cheap replicas and the insustainability of that type of replicas. Also because often they're not even made in the United States, they're made in in the Far East, making people working like slaves in factories and so forth. So there is a huge argument for protection for that. However, if you take away the incentive, then the company have to produce on quality. And the higher the quality, the less the likelihood that the cheap replicas can actually meet the same demand. And so I keep going back and forth. We need more protection with no protection, just to try to pinpoint. But there is a problem with not good replicas. There is a problem of flooding the market with there is the price of too much competition, the price of low quality has a major impact. I don't think trademarks is the answer. I think higher quality is the answer. But then how can you make consumer pay more when they can pay less? That remains a really main issue for economists to try to figure out with some data. So my question to you is, from a public policy perspective, how can we gather data to prove that these marks or this protection is actually a problem, or vice versa? Because I don't think we have good data in neither of the two sides.
Yeah, so the data question is interesting. I guess I would separate that into two goods. I would think of counterfeit goods versus knockoffs, let's say, right? So knockoffs, I don't know that there's actually a problem there. So in thinking in the US, where there is not so much of a protection on fashion designs, let's say, there's really not a problem in terms of having too little design, in every season. You seem to get plenty of designs that come out, and in some sense, because of the knockoffs, then it gets distributed to a much broader consumer group while still keeping the brand price, quite high. There's still a very high brand premium. So we think that the consumers sort themselves based on the trademark, right? Based on knowing that this is a legit brand and this is not. So I think the counterfeit is particularly important, right? I think we do want to limit counterfeit goods in the sense of copying the actual mark and saying, yes, this is Louis Vuitton or it's not. I bought a pair of sunglasses in Thailand that said genuine replica Ray-Bans, which I appreciated because at least they were putting it right out there. As far as the data, I think that where I really would like to see data is on what are we incentivizing with the various rights. And I think that people are doing some really clever research here, and I would actually probably open it up to the larger group, because if you wanted to know how much does design protection incentivize new designs, better designs, more aesthetic designs, I know that Beth has done some work on that, and I think it's a productive empirical way to go.
I think if there's no confusion, if you know that you're buying a replica, say a replica Eames chair, and you know that it has less quality, I mean, what's the problem? You can always go buy the real thing. And if you don't have the money to buy the real thing, why shouldn't you be able to buy the replica and know that it's a replica? So I think that the problem is really rent-seeking at that point, because you're not incentivizing anything. Oh, I've got a trademark, I've got this chair, I can charge £1,000 for it until the eternity. So why should I carry on investing into creating new types of chair? Then you're going to have your creators who will, because they will have a copyright on it. And so, why should I combine having a trademark and a copyright, or a trademark and a design? Because basically, I mean, I'm not an economist, but I throw this question to economists. It's really rent-seeking. In my mind, I mean, after a while, if it's something that's ornamental, or even more if it's functional, it should be in the public domain. And people should be able to make their choices. And if they want to buy the real thing, they will, as a special gift, they'll get the real thing. And if they want a replica, they'll get the replica. But as long as there's no confusion, what is the problem?
Yeah, I would just say the usual rule in economics is for introducing a form of intellectual property right is to increase the level of innovation, creativity, or ideas, or whatever it is, beyond what would naturally occur without the right. So if you've got enough design going on, or enough music being made, you don't need IP right, or additional IP rights, whatever.
And you wouldn't.
Status
you wouldn't
quo
want
is.
And
yeah.
the question is, with the stronger rights, give an incentive for excessive investment
exactly.
in design.
Yeah,
right?
That's right.
Yeah.
That's right. So there is such a thing as too many designs, or too many books, too many record CDs. If there's no other question, this is we're eating into the coffee break time here. But if there's no other questions, I think we should wrap up and thank our three speakers. Thank you very much.